comfortable, na?
Yes, sir.
Okay.
A very warm greetings to the esteemed guests, participants, and data enthusiasts from around the world. As we stand at the cusp of a digital revolution, the rapid pace of digitization has transformed not just industries and economies, but the very fabric of our daily lives. With the boon of digitization, however, comes the responsibility of safeguarding the vast amount of data generated every moment. One such landmark initiative in this direction is India's Digital Personal Data Protection Act 2023, which is a pioneering effort setting the gold standard for data protection in India. This legislation underscores India's dedication to creating a secure digital ecosystem for its citizens and business alike. Having set the context, now I, Prachi Mishra, Assistant Professor of Law at UPES Dehradun and a proud member of Galter, warmly welcome all the participants to the International Roundtable on Data Privacy and Protection Law. Today, we have a distinguished panel of speakers who are also the members of Galter, who will be sharing their expertise and insights on various critical areas of discussion relating to data privacy and protection. Each of our eminent speakers will be given an average time of 20 minutes for their presentation. I kindly request all the participants to keep their microphones on mute throughout the session to ensure a smooth flow. Also, I would request the participants to kindly rename themselves with your name and affiliated institute for maintaining the uniformity in the event. Once all the presentations are concluded, we will open the floor for a question answer or rather a discussion session wherein the participants can either type their questions in the chat or raise their hand to be called upon to speak if the time permits. Now, beginning with the event, it is my privilege to invite Professor Dr. M.K. Bhandari, the founding director of Galter, to delve deeper into the overarching theme of our discussion today. Over to you, sir.
Thank you, Prachi, for setting the tone for today's International Roundtable. Our international member, Alkali Amana, is likely to join shortly as there is a time gap. I also take the privilege and honor of welcoming all the members who are present here, and some of them are our distinguished panelists also. Friends, 11th of August 2023 is a landmark date in the tech revolution of India. On this day, our Honorable President signed the Bill Digital Data Protection Act, and the bill became the act. Although a lot of things are yet to be done, rules are to be framed, Gazette notification has already been published. This 44 sections and one schedule, which provides various penalties for the breach of the Act, has heralded a new era in accelerating the digital transformation journey of India. Although, if we critically examine the Act, which our experts will examine, there are certain lacunae, certain missings, which ought to have been there. But if we take an overall view of the provisions of the Act, I think in the present context, because it is an experimental Act, the Act takes care of a balancing approach between industry, commerce, individual rights of protecting his or her private digital data, use of data for special conditions, emergency conditions, rights and duties of the data holder, or what we call the owner of the data, principal data holder, and various other authorities, right from appellate tribunal to data protection board, fiduciary officer, data fiduciary, and so on and so forth. I think our members, panel experts will all discuss the various dimensions. Suffice is to say at this point that finally we have after a long struggle from Puttu Swami's judgment and Justice Sri Krishna's committee, finally we have a Data Protection Act, and we are 79th country in the world which has enacted the data protection law, dedicated Digital Data Protection Act, Personal Data Protection Act. Let us see how it works. Once the rules are framed, the act comes into operation effectively. At this point, I may also share with you one information, as my co-partner, Dr. Yatin Kathuria, is here. Recently, we have signed an MOU with SRM University Sonipat, that is the 7th in the series, and with Faculty of Law SRM University Sonipat, we are launching very soon the certification course, which will later on converted into the diploma course on private data protection, digital data protection law, and the related subjects. With these words, I again welcome to you on behalf of Galter and on my behalf. I am happy that large number of our members and participants are joining very briskly. Over to you, Prachi, for starting this roundtable. Alkali has joined. I can see him.
Thank you so much, sir, for enlightening us with the theme and for your valuable insights. Now, moving on, I would like to invite Mr. Aryan, the Legal and Policy Counsel at Flowbiz, Bangalore, and earlier with Legal Policy at FinTech expert, for his valuable insights on authorities and enforcement issues. We are honored to have you, Mr. Aryan, with us. Over to you, sir.
Thank you so much, everyone. Thank you, Prachi, for the brief introduction. I'm really sorry I won't be able to attend the entire panel discussion here because due to some personal reasons, I have to travel back to my hometown. So yeah, I'll be just covering the principal level of enforcement issues that I think there are with this particular draft of the Act. These principal issues will definitely help entire panel to initiate the discussion in terms of what are the core issues that we need to resolve further once the rules come out and once the industry starts implementing the Act itself. So given first, as we all know,
if you are comfortable, please switch on your webcam. If you are comfortable, otherwise, I know you are at the airport.
Yes, sir. I have low bandwidth of internet, so my data plan will get exhausted if I.
No, please. Yes. Continue.
Yes. So, starting with the genesis of the Act itself, it is a principle-based legislation. Rules are yet to be prescribed later. When it comes to rules to be prescribed later, the adequate framework of legislation is not before us, and the visibility that how to implement it, for whom to implement it, is not that much. Principle-based legislation are basically made to ensure that innovation and regulation exist together. But at the same time, once principle-based legislation starts getting implemented, a lot of hold over the enforcement and the implementation of those particular provisions are upon the self-regulatory bodies or the industry bodies itself, because these are principle-based regulation, soft touch regulations, and basically government authorities does not enforce it strictly. They try to harvest the innovation and let bloom the startup hub, or let bloom the tech intricacies in the industry. Now, if you see this particular legislation, there are lots of matters of implementation that has been left to the industry practices itself. and that's why they have taken time to implement the rules and they are between the time of notifying the legislation and prescribing the rules. They are taking consultations with the industry itself, that for which rule what kind of procedure is to be prescribed. So there, I'll share a link also with this forum regarding an article that I recently read, where the author made a really good point about that why data protection should be should not be a principle based legislation, but should be a uh, the rule based legislation, and the rules and the principles should be all set by the government itself. It will definitely make a good read for all the academia participants to debate about why we need to have a rule based legislation and the principle based legislation. Moving forward, if you see the applicability of the act, so when it comes to the applicability of the act, there is one exemption under section 17 of the DPDPA, that is regarding that if any contract that is happening with the law of the outside country, but even if it is serving the Indian citizens, then that will not be considered under the regulation of DPDPA. So there are lots of issues when it comes to betting websites. There are lots of betting websites, Bet 365 and all these kind of companies which regularly serve Indian customers who are interested in betting over the games of cricket or over the games of horse racing. If you see the intricate part of their privacy policy, it specifically says that the governing law will be of the law of England or the law of Australia, wherever these particular companies are situated. Now, such kind of contractual provisions will definitely make such contractual arrangements being regulated by the acts of those particular countries and not India's. So I think there is definitely and there are lots of cyber crimes that are happening in terms of Bet 365 kind of websites, because they definitely take your commission or the fee from you for serving you, but ultimately they don't deliver the service or they don't deliver the reward that you have earned. And such kind of cases then comes up with the cyber security officials. So definitely, DPDPA should also regulate when it comes to the collecting the personal data of customers through these betting websites, and such kind of provision should be provided that even if you are doing the law, even if you are incorporating the law of any outside country, but you are serving the customer in India, just like GDPR, then the act should be applicable to you itself. Getting to the notice requirement, you see, the collection of digital personal data can only happen on two grounds. That is, one, that you are doing it by the consent of the customer itself, and second, that you are doing it for the legitimate uses or lawful purpose. So when it comes to legitimate uses, it is a deemed consent, and it is for variety of grounds. That is, that you have voluntarily acted, that you have given your data on your own voluntarily, and in exchange of any service to be done by the data fiduciary or the service provider, and that's why you have given up your data. Then there are other purposes like judicial decree enforcement. If there is any judicial decree against you and investigation agencies need data from you, they can collect and they will consider it as a deemed consent. And obviously, one essential one that has been added very specifically is the employment purposes. That if you are if you're getting recruited at a particular organization and employer seeks your personal data related to basically your address and all, so as to reduce its loss and liabilities once you resign from the organization in future. So in those particular terms also, the employer considers your deemed consent once you gets recruited, and they can collect your data. So when it comes to the grounds, there are two grounds, that is that you are giving your consent for, and secondly of the legitimate uses. So how to take this consent, this need to be implemented by the organizations, and the specific requirement to take that consent, that you first give a prior notice, right? Before obtaining that consent, you have to give the prior notice, and you have to ensure that the notice covers all these kind of requirement, all these kind of fields, that you are definitely disclosing the purpose for which you are collecting data, what type of data you are collecting, and then necessary safeguard that you are providing with respect to that data to the user itself. Now, if you see the burden of proof on within that section 610, section 6 subclause 10, you can see that the obligation or the burden of proof of the entire, that the consent has been obtained and the notice has been provided, will be on the data fiduciary itself and not the data principal. That's like any other beneficial legislation. If you go through RBI laws as well, you will find that RBI bylaws also make sure that the fraud should be proved by the data service. Fraud should be proved by the service provider, not the user. So these are the beneficial consumer legislation, and there is no problem with the burden of proof. But how the burden of proof should be proved? What are the consent log mechanisms that the companies need to procure and maintain? So those kind of standards have not been provided yet, and the companies that have already started, such as big techs, because they are the first one who will have to implement all these rules and principles within their working capacity. And the startups and other kind of organizations will be, or non-profit organizations will be exempted for a certain time period. So I think the big techs are in now kind of flux that how to what kind of security measures are needed to be implemented in order to ensure that uh, the burden of proof, they'll be able to prove the burden of proof regarding the basically your notice and consent requirement. At the same time, the rules have taken a leeway in terms of that they'll be prescribing the format of notice. So there is one interesting document that I will definitely refer you to, you everyone on the panel to, and that document is the consent architecture provided by the Aadhaar. So Aadhaar has provided UIDAI, that is the regulating authority of Aadhaar database, has provided a document regarding what is the proper notice format for the consent when you are obtaining consent for KYC purposes and the Aadhaar verification purposes. That document is a huge document. It is around 40 pages document. I do not think that a DPDPB, that is the Data Protection Board, should come up with such a huge document, because notice format are meant to be kept quite short, and such notices which are short as well as quite descriptive and indulgent, that a customer will be or the user will be interested to read that, such kind of notice format should be provided. So that's a very important requirement, and I hope that whenever DPDPB comes up with that particular notice format, it should be as short as of one page, not a huge page document like what Aadhaar did. Now, consent. So if you see with consent, the kind of implementation issues that I see is that again it is again a yet to be prescribed rule. So it depends on that again. But when it comes to consent, what is definitely required here is that the consent log mechanism should be created with a standard, and that standard should be implemented industry wide, and that standard should be something which is very strict, or which is something very burdening for the startups, and yet it should not be something very flexible or lenient for big techs. It should be a measured one. It should be based on the best practices that are out there, cross jurisdictional. At the same time, when we see consent, so if you see, with consent also comes your right to withdraw, that you will be providing your consent and later you want to withdraw that consent. So that should be with the similar ease. That is what DPDP is trying to ensure. But I can assure you that when it comes to implementing right to withdraw, it's not possible, because you obtaining the consent in a wider forum. You're obtaining consent by offering your services online, and the customer can come and just choose to give its data and give his consent. But the same cannot happen for the withdrawal, uh, because for withdrawal, one particular customer out of the entire cohort would have to apply, and therefore there would be a different kind of a way that needs to be implemented. But the act imposes that the requirement of the consent should be the requirement of right to withdrawal should be provided with a similar ease as of consent. So that's also need to be looked at, that when they are using words like such subjective words like ease, and when they are using flexibility and all those kind of words, how should they be inferred, and what are the detailed uh, inferences that we need to make of such kind of words. Coming to the consent manager, so consent manager is a very unique item of the entire DPDPA. It is ensuring the kind of innovations that are happening out in our Indian infrastructure, and that's related to the digital public goods, that is your DPIs, digital public infrastructures like UPI and account aggregator. So consent manager has definitely validated the mechanism of account aggregator. Account aggregator is was basically one entity from where you can manage all the consents that you have provided to different digital service providers. Now when it comes to consent manager, right now if you see, master directions on account aggregator already deals with what kind of entities will be account aggregator, what are their duties, what are the kind of eligibility requirements they need to fulfill, and what are kind of the functions they will do. Now at the same time, DPP will going to be register these consent manager entities, that is the data protection board. So I'm quite in a flux that how this dual or the redundancy of eligibility requirements and registration is going to happen. And definitely the DPB, whenever it comes with the rules, it has to ensure that it makes a distinction that if you are being regulated by any sector, any financial sector regulator, that is RBI, IRDI, then the such rules will only apply to you, and not the DPB rules will apply to you, and not you have to register yourself with the DPB. So all those kind of measures should, or those kind of wordings should definitely come out with the rules, and must be ensured.
Aryan?
Yes, yes.
Yeah, thank you. Actually, I would like to remind you that you have to board your next flight as you are at airport. So you can kindly sum up in next 2 minutes. And thank you for joining under odd circumstances.
Yes, yes, Professor.
Please
So
sum up.
coming to legitimate uses, definitely there are certain kind of legitimate uses that has been left out, that have been left out. Such are basically your credit information companies. So your credit information companies, when you want to definitely get your credit report or get your credit report verified when you are availing a loan, such credit information companies have a deemed consent, and that has been covered in the previous version of bill, definitely by way of using the word deemed consent. In this particular section regarding legitimate uses, we have seen that the specific wordings of deemed consent has not been used, or specific wordings that CIC can use it has not been used, although it has been used in the exemption under section 17. So that is also a clause worth to look at in terms of the implementation. I would come to directly to the implementation of the rules and the act by the DPB itself, and whether that would be feasible within the current uh, framework that they have decided upon or have determined. Uh, if you see, the entire board can be appointed by the central government, so it is basically against those kind of prescriptions that we have been dealing with for a long time now. That the appointment of the members should be by different kind of members, where your leader of opposition should also be included, CJI should also be included, and definitely three members from long service in that particular sector also be included. So you can see that currently it is entirely up to the central government that whom they can appoint within the data protection board. So that's also being debated largely within the ecosystem, and we need to seek out a way that how to make sure that central government's appointment to the DPB will be transparent. uh, Also, there have been introduced a voluntary, basically, a voluntary compromise between the two parties. That is the data fiduciary and the data that is the data principal and the data service provider. If data service provider thinks that he has breached the law, he can get out of it by using a voluntary submission before the DPB. So the particulars regarding or the rules regarding that has yet to be come out. So that's also need to get resolved, that or what kind of third-party entities will decide, that is the ADR entities, alternative dispute resolution entities, will decide that data breach has not happened at that magnitude that it can be basically condoled. So those kind of parameters has also must also come out in detail within the rules. At the same time, when it comes to the punishment against the data principle itself, so this is the first of its kind act in the entire world that has also introduced the duties that the data principal has to ensure while availing the services from data service providers and giving up his personal data, and also has imposed punishment regarding to it, that is the INR 10,000 punishment regarding the same, that if you are impersonating, if you are using fake account, or giving up your fake data and that is not authentic for availing digital service provider, then DPB can impose penalty on you as well, the customer as well. But no details have been provided that who will be able to complain against such data principle, whether data service providers or the data fiduciaries can complain against that particular user or not. All those kind of details has not been provided. So what we are right now thinking is that, or wondering is that, uh, data protection board, when will be investigating these issues, they'll be able to decide upon that the particular customer has not come with the clean hands, and that therefore the penalty should be imposed on it. So these are
Aryan,
the
thank
kind of
you.
broader
Yeah,
principles I would like
please,
to lay out.
please. Yeah.
And I think the panel would be now able to discuss this in detail and find out the issues, or find out the uh, resolutions regarding these issues itself.
Thank you, Aryan. Thank you very much for joining and elaborating about the various critical provisions of the Data Protection Act and pointing out some of the uh, worrisome issues regarding the rights and obligations of the uh, data principal and other authorities. We will discuss it during discussion. We have with us, Prachi, please allow me, we have with us Dr. Aparajita Bhatt, who is joining from Jodhpur, and she is about to travel in next 15 minutes. Dr. Yatin, I would seek your permission again to put you on hold for 10 minutes, if you allow. I know you are also in Kashmir with family enjoying holidays, and I promised you that you will be the first to speak. And in fact, your topic is also first to be undertaken. But these two exigencies have come, Aryan, as I told you, and Aparajita, because of her greatness, she could not tell me no. So she said, sir, if you can spare me in 10 minutes, I will join and pitch my subject. So please bear with me. Next, you will be there. So we are taking your much time, and your family must be getting angry with me. Please seek my apology from them. Yeah. Prachi, you can invite Parajita, please.
Yes, yes, sir, sure, sir. So thank you so much, Mr. Aryan, for such an enlightening session. Now, with immense pleasure, I would like to invite Dr. Aprajita Bhatt, Associate Professor at NLU Delhi and Head of Cyber Center at NLU Delhi itself. Ma'am, we are honored to have you with us and would like to invite you to share your valuable insights with us. Over to you, ma'am.
Thank you so much, Prachi. Sir, good morning. Good morning to one and all present here. Thank you so much for having me here. And I'm really sorry for joining in late and for leaving early also. Dr. Yatan, I'm really sorry for encroaching upon your time. Really apologize for that. So I think this topic, data protection and all the issues which are associated with data protection, they're very, very common, they're matters of concern, and all of us know the gravity of the issue. Why do we need to protect the data? What is data? What is the value of data? Some say it's being considered as an oil. For some it's a new asset. It's an asset. For some it's a good. Looking into the fact that now we have data marketplaces where data can be bought and sold. So data also can be considered as a good or a commodity. So we still need to arrive at the exact interpretation of data. What is it? But whatever it is, whether an oil, wealth, asset, good, it is something which is very precious, very valuable, very personal, and needs to be safeguarded and protected. Of late, all the countries have realized this, including India. In India, we have realized this a little late. The legislation has been in pipeline since last 4 years, since 2018. But congratulations to all of us that finally we do have our Digital Personal Data Protection Act 2023, finally. Now, no piece of act or legislation legal framework is perfect in itself, and legislatures, parliamentarians keep on updating it, amending it from time and again. So which is fine, that's a natural process. However, we tend to compare and critically analyze the legal provisions of any legislation with its counterpart legislation in other parts of the world, in other countries. For example, GDPR, for example, other legal framework which are there in US, Singapore, Canada. And after making this kind of critical and comparative analysis, we understand what are the shortcomings in our own system. So one of the most prominent shortcoming for that matter is why to compare with other countries? If we compare our act with the bill of 2018 or 2019, many features of the bill have been taken away. They have been removed, which probably were required for a country like India, wherein our problems are peculiar. We have issues of digital illiteracy, digital divide, so many other things. When it comes to data contraventions, data theft, data crimes, we don't have trained personnel. We were giving a training, we were conducting a training workshop for LEAs a couple of months back, and that was attended by inspectors and DYSPs, officers of that level. And they shared with us, because the cyber crimes reported are so many number, that the number of trained professional investigating officers, that is people of the rank of inspector, they are, there's a shortage. They are less in number. And hence, in real time, in the field work, all these issues of data theft, cyber crimes, they are being investigated by officers of the rank of constable, people of the rank of constable, who are not trained. So why I'm sharing this is we do have ground level issues, ground level problems, which need to be identified and addressed to that code. Coming back to data protection and its shortcomings, two prominent things which were there in the bill and now have been removed, that is right to portability, data portability, and right to be forgotten. Now, these are two important features which were there in the bill. They are there in EU GDPR. They are there in other legislations of US, Singapore, Canada. Why not here in India? That's a question we should ask. We as citizens should be having, with our consent, again, a conscious, informed consent, right of data portability, so that we can access our data from wherever we want, especially in issues like it's a medical data, health-related data, any other critical data. I should have the right of data portability. Right to be forgotten. We have some best of the landmark judgments delivered by EU Court of Justice and other courts there, where right to be forgotten has been acknowledged. It has been acknowledged by Indian high courts also. But now that it's not a feature of the Data Protection Act, I fear that, it's a right which, subject to some terms and conditions, subject to some, restrictions or limitations, may be acknowledged, may be granted in limited applicability. Because we are an advancing country, the technology is advancing. The offenders, the people who take away our data without our permission, those who deal in data theft and all those things, they are not covered by any limitation or restriction. Then why should the citizens, why should the people be covered? So these are two important rights which have been taken away. Another concern in the act is the power of the state to, process the data in some circumstances. So this power of extreme data processing, it has enabled the unchecked data processing by the state. This may violate the right to privacy of our citizens. The government can always say, or the state agencies, the instrumentalities of state falling under Article 12 can always say that this was required, this kind of data processing was required in the interest of the country, unity, integrity, so on and so forth. All those factors which are given. However, there's a huge potential that the right to privacy of individuals may be violated. So we need to check that. That's one matter of concern under the Act. Similarly, the Act hasn't defined what can be the different kinds of potential harm, and it doesn't regulate the harm arising out of processing of personal data. So that's another important aspect, because if my data is being processed by any data fiduciary, and as a result of which I suffer a personal harm, a financial harm, a loss, a financial loss, who is going to regulate or monitor, control that aspect? And there's a likelihood that that would happen at a very high level. So what is the remedy available to an individual? A quick remedy available to an individual that I can move the regulator with my issue, with my concern, and I'm being provided the remedy for whatever harm, be it personal, be it monetary, a quick remedy is being provided to me. So that's another important concern which the regulators, which the legislators should have looked into. Besides, there are other shortcomings also, but one specific point, which, because I'd written a paper on this aspect, which has not been, I haven't found it in GDPR, I haven't found it in other countries, not even in India data protection. One aspect, the process of datafication. And what about the consumers or individuals' interest with under the ongoing datafication process which is happening? Now, this datafication process is not covered by Digital Data Protection Act, nor GDPR, nor any other. What is that datafication? How my human traits, my activities are being monitored, collected, compiled without my consent, without my knowledge, and are being converted into algorithms, with the help of algorithms, into numerical data, and are being exploited by the companies to be commercially benefited. So the entire economic or commercial benefit of datafication, which has happened through datafying my data, converting my human traits, my shopping habits, my browsing habits into numericals, and targeting the same thing towards me, all this process happening without my consent, without my knowledge. This is datafication, and they exploiting the entire commercial aspect of it, and the benefit being tilted to their favor, right? And I'm not a party to it. I'm not aware, and no benefit is being shared with me who's a consumer. It's a big industry. The e-commerce industry is a big industry. And this is all happening. What is the raw product of this entire mechanism? My data. My data. So this entire process of datafication is uncovered completely under most of the regulations, most of the legal framework in the world, except I found one regulatory aspect in Australia where they talk about consumer data right. So similar consumer right has been given to Indian consumers also under Indian Consumer Protection Act of 2019. However, consumer right does not include their data right. So acknowledging that data is a necessary wealth, asset, oil, goods, whatever we may call it, something which belongs to us individually, our personal data, we cannot allow this en masse datafication happening by these big tech giants and the entire economic benefit being tilted in their favor. So this is happening at nuanced micro level also, where individuals are being a part of it. And this is also happening at the macro level in the countries wherein the global West is taking away all these benefits from the global South. So I've written a small piece on this, a paper on this, wherein I put up this argument that which law is covering this aspect of datafication. So far as I know, Data Protection Act 2023 does not cover this process of datafication. It talks about consent, it talks about all those things. But the way datafication is happening, data-fied society. We are moving towards data-fied society. This is not covered by any regulation except this thing in Australia, which has come up with consumer data right, and they allow the consumer to exercise their choice. It's a matter of choice at the hands of the consumer. So this is one aspect which I thought I would share with all of you and put across all of you. But I think all of us here, including I'm the one who least know about, when it comes to critical analysis and identifying gaps. I'm the one who's not much aware. All of you are already esteemed and renowned panelists, and you are already stalwarts in this field and industry. So I'm not going to delve deeper into this, but datafication is certainly one aspect on which regulators and legislature need to keep a watch on, because this is happening on an en masse scale without being legally covered. Enough adequate legal protection being given to this part. So yes,
yeah, if
yes.
you will allow, you're talking about datafication. So China has recently launched AI Recommendation Act. Okay, so some aspect of datafication they are covering, where the consumer has the right to know the process, how the algorithm is working, how the algorithm is processing the data. But yes, that particular aspect that you can be the beneficiary of that particular thing, the
Yes.
money they are making out of it, that has not been covered. But yes, AI recommendation thing has been governed by China through this particular act. So
Yes,
I
yes.
think in year 2022 only they have come up with this particular.
Yeah, I'm
law.
aware, Dr. Yatin, I'm aware. China, Australia, and just
Yeah.
one or two more countries, very small
Yeah.
European countries, but most of the legislations are
They do
silent
not
on
have.
this aspect.
Yeah.
I mean, probably countries don't understand how big threat it can pose in terms of, everything is not in terms of personal harm caused to the people. Or when we talk about right to privacy, it's also economic or commercial harm, and which we don't realize. So
Yeah.
Thank you,
Yes.
Aparajita. Really, I'm personally and on behalf of Galter, I am thankful to you for sparing time. You are at your in-laws' place, engaged in some ceremonies. Thank you very much. There are many
Thank you.
issues. I think we want to spare you as quickly as possible.
Thank you so
So
much.
we will keep on discussing those issues which you have raised, specifically right to be forgotten and datafication. Our other speakers will throw some light, and whatever questions are raised during discussion, we will try to respond to them. I want to introduce our new member, Dr. Rajesh Methi from Indic School of Jurisprudence, Jaipur. He has recently joined. Dr. Rajesh, can you put on your
Yes, sir.
Yeah, you are
I'm
welcome to this meeting of the Galter Roundtable. This is your first appearance. Welcome.
Yes.
Now over to you, Prachi. Please invite Dr. Yatin for next discussion.
Yes.
Then Dr. Sharda Patil. After Yatin, we would be happy to listen to Dr. Sharda Patil.
Thank you so much, Dr. Aprajita, for such an enlightening and knowledgeable session, and for discussing a very good and new concept of datafication with us. Now, moving forward, I would like to introduce Dr. Yatin Khatoria. Dr. Yatin is an assistant professor of law in SRM University. He has a teaching experience of around 5 years and worked as an assistant professor in renowned universities in India. His research interests are artificial intelligence and law, data protection and privacy laws, renewable energy regulation, amongst other contemporary legal issues. Further, Dr. Yatin has published numerous articles in peer-reviewed national and international journals and has contributed chapters in various books published as a part of international conference as well. He has recently completed a certificate course on AI and law from University in Sweden. Further, he holds AI Appreciate Certificate from AI for All program offered by Ministry of Education, Government of India in partnership with Intel. His recent writings and presentations revolve around the juro-legal inquiries into the intersection of law and technologies, including what should be the legal definition of the term AI, whether legal personalities should be accorded to AI technologies or not, etc. Sir, we are pleased to have you with us and would invite you to elucidate the intricacies of data and metadata. Over to you, sir.
Thank you, Prachi, for such a wonderful introduction. And special thanks to Bhandari sir for giving me this opportunity and making me a panelist for this particular international roundtable on data privacy and protection. So while we both, Bhandari sir and me, were discussing about the themes, so I told him that why not to start with the basics instead of directly going to the data protection laws. We can start with what is data, what is big data, and what are the various characteristics of it. So I'll not waste much of your time. I'll start with the general definition of data. What is data? So general meaning of data is that it is the collection of the information, and you are collecting this information through various means, through observing the things, through measuring the things, or through researching over a particular topic. And how you can represent this particular data, it can be represented in the form of facts, in the form of numbers, names, figures, or in the form of a paragraph covering up the description of a particular thing. And how you can organize it, you can organize it in the form of graphs, charts, or tables, and etc. Now, one of the important, you can say, word or the group of people associated with the data is the data scientist or the data engineer. So these are the people who basically extract meaningful information out of this data, who make sense out of this particular data, or which is present in the huge volume. They give us value out of it. So these particular people have crucial roles in today's era. If you talk about data scientists and data engineers, they play a pretty crucial role, specifically in this particular age. Now coming on to the classification of data. So data can be classified into two broad categories. I'm talking about normal data, simple data, not the big data. So normal data can be classified into two categories, that is quantitative data and qualitative. So quantity simply means that the data which can be represented in the form of numbers, like the height of the person or the weight of the person. And quality is something which cannot be, represented in the form of number. It is in the descriptive form. And the examples are the color of the eye of the person, or the color of the hair, the texture of the hair, or anything which gives the qualitative information regarding a person will come under the category of the qualitative data. Moving further, now what is data in the digital world? Now, if you are writing or maintaining the data in a notebook or in your register or in a book, then it is data which is there in the non-digital form. Now, digital data is something which can be understood which can be understood by the computer. It is represented in the electric signals. It is converted into electric signals, and it is in the form of, you can say, 1 and 0, in the form of binary digits. So the quantities, characters, or symbols, which can be understood by the computer, and which can be stored and transmitted in the form of electronic signal, that is known as the digital data. Now, how data has been defined under Digital Data Protection Act of 2023, Section 2H of this particular act defines the term data, and you can see on the screen that it means a representation of information, facts, concepts, opinions, or instructions in a manner which is suitable for communication, which means you can communicate it to the another person, which is suitable for interpretation, which means that you can understand that particular thing, and the data which can be processed by the human being or by automated means. Now, what is quite unique in this particular thing is that in the definition of term data, we have included processing not done just by the human beings, but also by AI algorithms or by AI tools. Okay, So it is not only talking about the processing done by the human beings, but also done by the AI softwares. Now, coming on to the main topic of the theme which I basically to address is the big data. What is big data? So big data is simply the collection of the data in huge volume. Okay, and it is not just a stable collection of the particular data in volume. It is still growing. It is still in the continuous process. So when you have the data in such a huge volume that you are not able to process, you are not able to analyze by using traditional methods. Okay, by it cannot be analyzed by human being, by human mind. Okay, then we can say that we have a data in huge volume, and the processing is done by the smart softwares and the smart tools. We are not, as human beings, we are not able to basically done the processing or the analysis of that data. Even our traditional computers are not able to basically process or analyze this data. So we need smart computers, smart softwares, or the AI tools to process this data. Otherwise, the data which we have in such a huge volume will be having no meaning if we are not able to extract meaningful information out of it. Okay, so the foremost characteristic of big data is that it is in very huge volume that we are not able to process it through the traditional data management tools. Now, moving further, let us see the examples of big data. Suppose the first example you can see on the slide is that it's about the Facebook, how much data is ingested in the database of the Facebook on the daily basis. So around 500 plus terabytes of data is generated in the Facebook every day. And this data comes through various sources in terms of photo uploaded on the Facebook a platform, or a video uploaded, or in the form of messages exchanged by the users, or the comments made by the users on the you can say data posted, or any kind of post by the user. Now, another example is that how much data a jet engine can generate in just 30 minutes. It's around more than 10 terabytes of data is generated in just 30 minutes by a jet engine. And you can imagine how many flights basically per day we have throughout the world. So at this particular point of time, we are generating data at much faster rate and in huge volumes. So before moving further, we can just have a look over the unit of the data. So the smallest unit of data is bit. You all might be knowing that. So we'll go through it quickly. So 1 bit is the smallest unit of the data, and one nibble consists of 4 bits, and then 8 bits is equal to 1 byte. So if you are writing one character, one alphabet in your Word file, like if you are writing A or a B, that particular character will consume around 1 byte of the data. Then if it is one paragraph of the text in the Word file, it will basically consume 1 kilobyte of data. So these are the various units: gigabyte, terabyte, petabyte, exabyte. And these are the, at the last of the slide, you can see I've mentioned 3 units: yottabyte, ronabyte, and quotabyte. So these are the some units which we have added recently in last 5 to 10 years. Okay, so because the volume of the data is increasing, we are creating new units for that. So quotabyte, as per my knowledge, is the latest or the biggest unit of the data which we have as of now. Now, what are the various types of big data? There are 3 types of big data: structured, unstructured, and semi-structured. So structured data is something which is systematically arranged and which can be processed very easily. Unstructured data is something which is not systematically arranged, and it becomes difficult to process or to analyze this particular data. And semi-structured data, as the name justifies, that it includes both structured data and unstructured data. Now, the next topic is important. What are the significant characteristics of big data. So the characteristics of big data can be explained with the help of 5 V's. That is volume, velocity, variety, variability, and value. Now, what is volume? Volume, we have already discussed that the data is, the size of the data is enormous. It's huge. If that the data can be processed easily by the traditional process, we will not call it as a big data. We need smart tools. As I've already mentioned, we need smart computers to process it. So one of the primary characteristics of big data is that it should be huge in the volume, and you are not able to process it through traditional modes of data management. Now, variety in big data can be understood in 2 contexts. That is the nature of the data as well as the sources of the data. So the nature of the data, it can be both structured data or unstructured. And when it comes to the sources, it is coming from the various sources. Okay, it comes from the emails, it is coming from the photos generated on the internet, videos uploaded on the internet, or it is coming from the monitoring devices. Monitoring devices means now many countries, including India also, we have facial recognition, you can say cameras, as well as facial recognition technology deployed by the government agencies, so that they are keeping track of the people, of the citizens. So they also collect the data in huge volume. And China is the nation which is using this particular technology at mass scale. Okay, then data can be in the form of PDF, audios, etc. So variety here means that it is unstructured also and structured when we are talking about the nature of the data, and the sources from which that data is coming are also quite in numbers. So it can be video, email, photos, PDFs, audio, etc. Another important characteristic is velocity. Velocity here refers to the speed at which we are generating the data. We have discussed the data generated in the Facebook, by the Facebook every day. And I'll tell you the astonishing figure. I was reading in an article that from the beginning till 2000, the amount of data which we have generated till 2000, year 2000, is less than the data we are generating today on the daily basis. तो 2000 तक जो हमने डाटा जनरेट किया था, वो डाटा कम है जितना डाटा हम आज डेली बेसिस पे जनरेट कर रहे हैं. So we are generating data in enormous speed. The speed of generation of the data is very huge. Why? Because of the IoT, because of the Internet of Things. Every particular device which we are using today is connected with the internet. If it is your smartwatch, if your mobile phone, obviously your laptops, your home appliances, we are having smart homes today. Even our lighting system in the homes, they are connected with the internet. Okay, even I would like to share the interesting thing with all of you. Even now, the companies are creating baby products, specifically the diapers, which which can be connected to the app, and you can say the thing going on in that particular diaper can be notified to the parents through that particular app. So even the diaper of the kid is being digitalized. So why? Because we are using these devices in huge volume, and everything is connected with the internet. We are creating data at the enormous speed. Then veracity simply means the quality and the accuracy of the data, or you can say the authenticity of the data. If the data is not authentic, not accurate, then it is of no use for us. So this should be there. This is the important characteristic, that it should be authentic in nature. And value simply means that we are able to process that data, we are able to understand data, and we are trying to create value out of it. Now, as Aparjita ma'am also mentioned, that data has become a new fuel. Earlier, industries used to run on oil and coal. every other industry, whether it is education, whether it is any big plant or manufacturing industry, they used to have the electricity, they used to have the power to basically create the products or deliver their services. But for the industry 4.0 or the 5.0, data has become the new fuel. So if the company has huge amount of data, that company will be having the you can say huge value in the market. Okay. So these are the 5 characteristics of the big data, which basically separate it from the normal data and the big data. So if a data has all these 5 characteristics, we can say that it is a big data. Now, what is data processing? Now, data is available in huge volume. It is in raw form. It is in unstructured form. We create the data in the structured form. Then we try to analyze it and we try to basically derive value out of it. And we make useful decision based on the data analysis. Okay. So data processing is simply a method of collecting the data and translating that particular data into usable information. Okay. If we have data, then that is the information. And if we are analyzing it, then we are converting that information into knowledge. So you can say that data processing is basically collecting the data, processing it in the useful information, and then creating knowledge out of it. You can say this is the whole process of data processing. And data processing is done by the data scientist or the data engineer for a particular organization. And why we are doing it? Because through the analysis of data, the organizations, the business organization can make important decisions regarding their business, or they can grow their business in this competitive market by analyzing the data for their benefit. Now, what are the various stages? So there are 6 stages in the data processing. First one is data collection. You simply collect the data from various sources. As ma'am mentioned that there are various data lakes and data warehouses which are involved in selling and buying the data and even the analyzing the data. So company or the organization can collect the data from these data lakes and warehouses. So the first step is we collect the data which we want for our organization. Then the second stage is data preparation. It is also known as a pre-processing stage. In this stage, raw data is cleaned up. Okay, raw data is cleaned up and it is basically divided into such categories that this particular clean data will be used for this particular purpose in the organization, and this particular amount of data can be used for that particular purpose. So it is also known as data cleaning process or a pre-process where raw data is cleaned so that it is ready for further processing. So this is the second stage. First stage is data collection. Second stage is data preparation, that is cleaning of the raw data. Next stage is data input. Here, the clean data is input given or feeded to the softwares which are capable of, you can say, processing this particular data. So data input means we are feeding the clean data to the data softwares for the processing purposes. Fourth stage is the processing, where the computer basically, or the softwares or the machine learning algorithm, they process the input data and they basically give meaningful information out of that particular raw data to us. Okay. Then last stage is data interpretation or data output. So after the data is being processed by the smart computers using the smart softwares and AI tools, the data, these tools basically give the data to us in the form of structured tables or in the form of systematic reports, so that it could be understand by the readers or by the users or by the organizations. Then data storage, this is the last stage. After data is interpreted by the softwares, it is being stored in the warehouses. so that it can be used immediately or it can be used in the future. So if you talk about the GDPR has provided various guidelines for data storage also. So if any company organization is involved in data storage thing, then they have to follow various compliances, various guidelines as provided under the GDPR. So these were the 6 stages involved in the data processing. If you talk about the general data process stage. Now, how data processing has been defined under DPDP Act 2023. Okay, so this particular act defines data processing as a whole or partly automated operation. So it can be completely automated thing performed by the AI tools or the softwares, or it can be done manually also. Okay, and it is performed on digital personal data and includes here because this particular act talks about personal data, so it has mentioned the processing with reference to that digital personal data only, not the other data which is not considered as the personal data. Okay, so it involves operations performed on digital personal data and includes operations such as collection, recording, organization, structuring, storage, adaptation, retrieval, use, alignment or combination, indexing, sharing, disclosure by transmission, dissemination, otherwise making available, restriction, ensure, and restriction. So you can see such a wide scope has been given to the term data processing under the DPDP Act. The different stages we discussed, all these stages have been covered in this particular definition. But what is interesting is that they have also included these things. That is, if you are, if the organization is transmitting that particular data to another body, to another organization, or if they are restricting some kind of data, that is also the part of data processing here. Or if they are erasing or destructing or removing the data, that is also a part of data processing under the DPDP Act, which is normally not considered as the part of data processing, as we have discussed the 6 stages. So this is quite unique that under the DPDP Act, we have basically included restriction, erasure, removing and destruction of data as also the part of data processing. Now, moving on to the last slide, that is why the data privacy is important these days. Because obviously because of the big data, obviously because of the social media platforms, and specifically for India, because we are number 1 in terms of internet usage, we are number 1 in terms of social media usage. That is why the battle against data privacy at the world level, at the global level, was not as important as of now, because India, which basically has the more and more people using these social media platforms, have recently announced Data Protection Act. So the battle has become more, you can say, interesting or challenging now. So you can see I've mentioned various biggest data breaches of all the time. This is the first breach, is one of the biggest data breach as mentioned by World Economic Forum. That is regarding the Aadhaar data breach, which happened in 2017. More than 1 million data of more than 1 million users was compromised there. And the interesting thing is that this particular data was available just for $4 through the WhatsApp per person. $4 per person, you can have the personal data of the citizen of India, because it was leaked by some external, you can say, hackers. Then Facebook in 2019, I guess, more than 530 million users data was compromised. Then in 2013, 3 billion Yahoo accounts were leaked, affected. And LinkedIn is not also spared. More than 700 million LinkedIn users information was compromised in year 2021. And these things are in continuous process. These are still happening and has not been, been stabilized. And that is why the countries are moving towards regulating these social media platforms, and specifically the big data. So that's all from my side. Thank you.
Thank you, Dr. Yatin. You have raised very fundamental issues regarding understanding the dynamics of data. What is, after all, the data and big data and metadata all is, and how it works, and what is its impact in our daily life. We will discuss all these issues during discussion. Thank you for sparing time out of your holidays. Now, please go back and enjoy the heaven on the earth. Enjoy the Srinagar, Dal Lake, and all these beautiful places. Thank you very much. Over to you, Prachi. I would like to also introduce Amani Alkali, our Galter member, who has been always very, I would say, readily active to participate in our deliberations. Few months back, he was part of the international symposium organized by the Sharda ma'am and her college colleagues. Hello, Alkali, how are you?
I'm fine, thank you. Good morning.
I got your audio message, and I'll talk to you later on that.
Okay.
Yeah. So
okay, that's fine.
I'm sorry that we will miss you in international conference.
It's
Physically,
sad
but
myself. I
certainly,
would have loved to come.
certainly we will have you online as we did have you in the symposium.
Okay.
I also welcome our few guests who have joined today, and I think few of them are the students of Anuradha Maheshwari madam, as she informed me, and few maybe other. And we also welcome respected father of Sharda ma'am, who at the age of senior age of more than 80 years is with us. That shows that the process and the eagerness of learning does not admit any age bar. Thank you, sir, and welcome, sir. So over to you, Prachi, for next round.
Thank you so much, Bhandari sir, and thank you so much, Dr. Yatin, for such an enlightening and detailed presentation. Now let's broaden our horizons and shift our focus to the African continent. I will now introduce Mr. Amana Alkali, who will discuss the challenges and the solutions surrounding data protection and regulatory compliance in Africa. Mr. Alkali Amana is a tech industry journalist, editor, and public speaker. He specializes in areas like blockchain, fintech, startups, and SMEs, Web3, technology, and SDGs. Mr. Alkali Amana has covered the blockchain industry and happenings as a writer and editor for over 2 years across several platforms. Notable names and brands in his portfolio include the African Leadership Organization UK, Arius Denmark, and Cornet Blockchain, amongst others. He is currently the acting associate editor at the African Leadership Organization for the African Leadership magazine. Sir, we are honored to have you with us, and we would like to invite you to share your valuable insights with us. Over to you.
Well, thank you so much, Ms. Prachi. I'm well conversant with you. Thank you. Thank you, Professor Bhandari, and Madam Sharada. I see you. Thank you so much.
Good morning.
Good morning. Yes, good morning. Okay, so I'll start my presentation immediately, but not before clarifying. I have left the African Leadership magazine, so I'm no more associate editor at the African Leadership magazine. Yes, but very soon I'm going to have something else, and once I'm done with what I have at hand. So my discussion this morning is on the challenges and issue of data protection in Africa. And we're going to look at what data protection is in Africa, an overview of data protection and privacy laws in Africa, and what it means down here for us in finding our path. Please, can you see my screen?
Yes, we can see.
Okay. So right now on the African continent, what we have is that we have over 36 countries out of 54 that are actively participating in creating data protection laws or regulations. And we've had the African Union Convention on Cybersecurity and Personal Data Protection, which 16 countries have signed. And most recently, we have seen a lot of countries come into the African space in terms of a transfer of personal information across the borders. As technology increases, you have a situation where, let's say, a company in Europe is providing service for people in Africa. You discover that data transportation happens over the internet. They get data from Africa and they go to Europe. Now, the major concern concerning or on data protection and privacy is you think that these big wigs are going to sell data, they are going to advertise data. And people are saying, how do I protect my data? How do I not fall victim to all of this? Now, in Africa, we have two major organizations, especially again, Africa and West Africa, two major organizations that help with the regulation of data protection. The first is the African Union, which is the mother body of the African continent. The second is ECOWAS. ECOWAS is the body, the Union of West African States. Now, aside these two, we have here a map of countries in Africa that have adopted data protection regulation. And out of these countries, the key countries are Angola, Benin Republic, Burkina Faso, South Africa, and Tunisia. Most recently, Nigeria just adopted its own Data Protection Act, and that was in June, I think on the 12th of June, 2023. It's a welcome innovation. So far, so good. Other countries that are in the works for data protection in Africa include Algeria, we have Kenya, we have Malawi, we have Uganda, and Rwanda. Uganda has an existing data protection law, but it is not strong enough. So now we're going to examine the most recent data protection laws in Africa. Now, just like I mentioned, Nigeria has had a data protection bill in place since 2010, but until June 2023, Nigeria never signed a data protection law. And with this Data Protection Act, what we have is that we have a legal framework for the protection of personal information. We also have it for the regulation of personal data that ensures that Nigerians don't fall victim to data scams. Again, Nigeria has proven itself to be a major player in the African marketplace, especially given that we've had the first unicorn come out of Nigeria, and that is Flutterwave. Aside Flutterwave, we've had something like Paystack. Paystack is another heavy fintech company that has come out of Nigeria, recently acquired by Stripe for $200 million plus. Now, these guys deal with heavy data. And if there is no Data Protection Act to cover up or to protect the data that people give to them while they carry on their fintech services, definitely there's going to be a problem. Eswatini in 2022 gave its own first piece of legislation on data protection, and this was published in its own government gazette. Now, this law applies to controllers and processors of data who are domiciled in Eswatini. Beyond Eswatini, formerly called Swaziland, we have Tanzania. Tanzania also has enacted its own Data Protection Act. Now, these are three African countries with the most recent Data Protection Act: Nigeria, Eswatini, and Tanzania. If you recall, I told you earlier when we started that we have 36 countries in Africa now either considering or having passed a Data Protection Act in place already. It shows you that Africa is coming to terms with the fact that data protection is big market. When you go to the black market or when you go to the dark web, you discover that people sell people's data. There's a marketplace for data, although not sanctioned, but they sell people's data, and that is actually not on par with international standards. Now, what are the issues or challenges surrounding data protection and privacy in Africa? The first here is that there is data infrastructure security concerns, right? So people use phones until now, actually globally, not just Africa, people use phones that do not or cannot detect when your data is being stolen, okay? And that is a concern. Beyond the infrastructure, also some people that build applications, these applications can steal personal data. Some people that build websites, you go on some websites, they are not SSL verified or certified. They also can steal your data. For instance, your credit card pins. You look also into situations like sensitive information you give out, maybe information about your height, your weight, your blood pressure. It goes on the internet. Some of these sites are not secured. And so data can be stolen and sold to some of these big pharma companies, these big pharmaceutical companies that can use your data for what they call it, for their research, though illegally obtained. The second problem here, we have low awareness and education. People don't even know that their data is being stolen. Then we have cross-border data flow, right? You want to transfer data from one border to another, but there's no comprehensive regulation or legislation. Now, if companies in Europe come to Africa to take data and there's no regulation to stop them, it means there's no limit to what they can do. I think it's also the same when you look at it in the Asian context. For instance, if let's say a service provider in Denmark goes to India and they're providing service to people in India, and there's no regulation that stops them from taking data of people from India, then it becomes a problem because there's cross-border flow challenge, cross-border data flow challenge. Then again, data privacy in government. I'll highlight this because it is important that if there is no data protection and privacy in government, how then can the government protect its own people from data theft? So it starts also with the government. When the government is able to secure its own self, then it can secure its people. When you look at the Edward Snowden situation with the United States of America, it also made Americans to lose trust in the American government. Why? Because at the end of the day, if American government cannot protect its files, how then can it protect its people? Now, what are solutions to these issues or challenges I have highlighted? Because of time, I cannot run through the whole challenges and issues, but I'm taking the key points, and also I'll give you key points on these solutions. Now, the very first solution we have here is towards comprehensive data protection laws. If there is no comprehensive data protection law, there is no way that people or data can be protected in any ramification. Again, there should be robust cybersecurity measures. Cybersecurity is something that is growing by the day. And as it grows, it also shows that ethical hacking is possible. So government, people, including institutions, schools, should be looking to develop the love for cybersecurity in their students, right? You have an institution, if your university can create a cybersecurity department, this is one way of protecting data. This is one way of creating people that can protect data. Then we have also here that regulation for emerging technologies should be provided. One thing I appreciate with Galter so much, and what Professor Bhandari is doing, is that we cover emerging technologies. We don't just leave it at Web3, we don't just leave it at blockchain. Emerging technologies, the metaverse, we look at artificial intelligence, and whatever iteration of Web3 there is, we look at it. It's very, very important that whenever a new technology comes on board, we sit down and create regulations for these emerging technologies. I was more than happy. Most recently, I covered in my newsletter the European Union Act on Artificial Intelligence. And I believe that other continents, other countries are going to follow through on that. Again, there should be access to legal remedies. One of the challenges as to why data protection is not readily dealt with is that there are no legal remedies. The question is, when you go to court, how do you prove that your data was stolen? And how do you prove that that data being stolen cost you problems? You know, the damages can be unquantified. So all of that have to be factored in considering data protection. Now, how do you ensure regulatory compliance? How do you ensure that when companies come to your country, they would comply readily with your data protection laws? The first thing to do is establish regulatory authorities. Happily, I can confirm to you that with the data protection laws and acts that are being put in Africa, most of them come with establishing data protection bodies. Like in Nigeria now, we have the Nigerian Data Protection Bureau in place that comes with the 2023 Act. So it's important to establish regulatory authorities. Also, you need to raise awareness and education. The average person that uses a telephone, once you have a telephone, you should know that your data is susceptible to being stolen. Again, you should promote public accountability and allow for establishing whistleblower protection. So somebody in the company should know that if something is not being done ethically, they can come out and say, no, we don't appreciate this. And as a whistleblower, they can be protected. Now, what are the innovations and opportunities for data protection and privacy in Africa? When you are in India there, or from India, or from any part of the world in Asia, and for those of you in Europe, when you look down into Africa, there are a lot of opportunities that you can leverage when it comes to data protection. First, you look at local data protection solutions. African tech startups and companies are actually becoming homegrown solutions for data protection and privacy. One thing I know is India is a technological hub. So with your technology, why don't you come and partner African tech startups? Look for African tech startups that have the propensity to deliver highly on whatever gains that can be given in terms of data protection and leverage with them. Secondly, you look at blockchain for data security. I think in all of this, the opportunities lie with partnership. That's the central theme. You can take whatever company you have in India to become a global force, a dominant force, and come down to Africa and see a situation where you can partner with African companies, with African institutions, and build collaborative innovations or initiatives. Then you also look at data protection as a service. Is very, very possible. So with your brilliant minds down there in India, and with also the brilliant minds of people in Africa, a lot of people that don't know about data protection, we can create something that provides data protection as a service. So you have people subscribe to this service to ensure that they're being protected and their data is being kept well enough. Then you can provide also cybersecurity incubators and hubs and digital identity solutions. Now, in conclusion, for my presentation, I'm saying that Africa is growing in its efforts towards data protection and privacy regulation. It opens up a market and a possibility for collaborative opportunities. I've been to India, I've seen what India can offer, and I can tell you for sure that an academic group like Galter, for instance, can partner with African institutions and governments and businesses and see what's possible in terms of leveraging data protection and privacy regulations to provide a better world. Thank you very much.
Thank you so much, Mr. Manal Kali, for enlightening us with the data privacy regulations in Africa. It was truly an enriching session, and we literally got to know about the regulations that are there in Africa and how are they being implemented. Now, with immense pleasure, I would like to introduce Dr. Sharda Patil, who will discuss with us the principles of data privacy and protection.
Prachi?
Yes, sir.
Please allow me to make a few comments on Amana's presentation.
Sure.
And then please invite Dr. Sharda Patil. Amana, you have very rightly said in your concluding part that the educational platform like Galter can explore the possibilities of mutual cooperation with your African institutions or authorities and work out toward new innovations, new techniques, not only in the area of data protection and data privacy, but in the entire gamut of advanced technologies. Yes, it's a very good suggestion, and I think you can take it forward, and whatever support you want, we are willing to be part of any such mutual beneficial cooperation, and you can discuss with me later and we can explore. And you can identify some universities or institutions or governmental agencies where we can discuss, talk, and find out. As you know, we are already have a MOU with two American institutions, and we are rolling out a course on digital forensic with the US-based institution. More details will be shared in time to come. Thank you for sparing time and sharing your very thoughtful views about ways and means of data protection and data privacy. Thank you very much. Over to
Thank
you.
you. If I may, please, before you go. So today is Nigeria's independence. If you have Nigerian friends, I would say you should wish them a happy
Oh,
Independence Day.
great.
Yes.
Yes, we all join. We all join
Wish you happy
in
Independence Day.
Happy
Oh, thank
Independence
you.
Day to you and to your mother country and all fellow
Thank you.
Nigerian friends. Please convey
Thank you.
our greetings and best wishes for the progress of your country and your
Good.
citizens.
Thank you. We will do that. Thank
And
you very
all
much.
my members are with me in conveying this message. Thank you.
Thank you. Thank you.
Okay.
Thank you so much, Bhandari sir. Now, with immense pleasure, I would like to introduce Dr. Sharda Patil, who will discuss with us the principles of data privacy and protection. Dr. Patil is a former principal of KLE College, Hubli. With 24 years of experience in academics, Dr. Sharda has contributed to the academic community in the form of her research, expert talks, and enlightening presentations in reputed conferences. Ma'am, we are honored to have you with us, and I respectfully invite Dr. Sharda for her presentation. Over to you, ma'am.
Before Sharda ma'am takes the charge, I would also like to add that Dr. Sharda Patil, madam, is one of the senior academic scholar, legal scholar, and one of the most active. All members are active, but she is one of the most active member of the Galter. With her collaboration, we have organized an international symposium at Hubli, partly physical, partly online. And our senior member, Dr. Chandrika Subramaniam from Australia, came to attend that, and Alkali joined us online. So we are also in process of planning many other activities with their college and with the support of ma'am. So thank you, ma'am, for your support, and you are welcome. Over to you.
Thank you, Professor Bhandari sir, and thank you, Prachi, for giving me this opportunity to speak on this occasion. Actually, I am personally more interested in data protection law since beginning when I started using internet and when I started using computers. I was amazed to see this technology and how they are providing this service and how technology works. I went on learning and I just joined Bhandari Research Institute also to continue to learn that all those things. At the same time, I went on thinking as to why these services are given free of cost by these service providers, Microsoft and all. When I opened my first email account in the year 1999, I felt why Microsoft is providing or giving free service. So now we are realizing the potential harm that may be caused, or the use of the big data and the use of the data that they collect and they use it for the business purposes. So now we are discussing of protection after so many years. Of course, we are, even though late in discussing all these things, many countries have started thinking about it very long back. Uh, it is actually the European countries only which started more thinking in terms of protection of data. Of course, we had started the discussion of protection of right to life and right to personal life, right to family life, etc. Soon after we adopted UDHR, but right to data, which became very important because the organizations started growing and they started collecting huge data, they started storing and using huge data, and the cross-border exchange of data also started happening, and there was economic freedom across the countries, as a result of which the countries felt that there is a need to protect data of the persons, or the protect data whatever is collected by these companies, and there should not be any abuse or misuse of this data. So way back in 1980s only, the OECD countries came together, they formed an association and they came out with guidelines in the year 1980. I think about 38 countries joined together to come out with the basic principles for national application with respect to data protection. So it is these basic principles which were adopted by the OECD countries. They form the foundation for the protection of data privacy or data processing in almost all the countries. All the countries are relying upon these principles only while enacting or adopting any law. So I felt I should begin with OECD guidelines only, where 8 principles have been identified and they have been applied, and even now also they are using, OECD countries are using these 8 principles, and nationally they are coming out with laws based upon these 8 principles. In this, among these OECD countries, even UK, Japan, America, all these are members of OECD countries, and they are signatory to this guidelines, and they follow these principles in their local laws. So let me first discuss OECD guidelines and then come to GDPR and then come to Indian law. I felt that these principles of data privacy, they form the basis of protection of the data that is being collected. So the 8 principles that have been adopted by the OECD countries through their guidelines in the 1980 are so very important, and first among them is collection limitation principle. First principle, that is collection limitation principle, which says that collect only that is absolutely necessary. You cannot collect more than that, and that has to be collected lawfully and fairly, of course with consent or knowledge. So that is first principle the countries have to follow. Before collecting any data or any information, you have to collect it only if it is necessary, lawfully, with consent or knowledge. Without that, they cannot collect. That is the collection limitation principle. And then another second principle that is adopted by these countries is data quality principle. That is, only relevant data has to be collected, the complete data has to be collected, accurate data has to be collected, and that data has to be up to date. That is, there should not be confusion, or there should not be any kind of garbage kind of thing that is adding to it. There must be accuracy in the data that is collected. That must be true data. It should not be false data. So all these are the things which have to be taken care of while collecting the data. So that is the data quality principle that has been followed by these guidelines. And the third one is the purpose specification principle. Whenever you are collecting the data, you have to tell the customer that why this data is being collected. Without telling the purpose as to why data is collected and what for the data is going to be used after it is being collected, the data cannot be collected by the person, by any company or by anybody. We go to a pharmacy and they collect our mobile number. We simply give our mobile number and we come off. They don't even tell that why they are collecting that mobile number. If we don't give mobile number, so many times they refuse even to give the medicines also. So here it is a kind of protection which is ensured by this guideline, this particular principle, that they have to specify the purpose, and only when the purpose is specified, the data can be given, and the data has to be used only for that purpose only, not for any other purpose. The fourth principle is the extension of this purpose, this principle, that use limitation principle. Use limitation principle specifies that you have to set those purposes and use the data for that purpose only. You cannot use it for any other purpose. Of course, you can use it for any other purpose if the law permits, or the authority of law, that is legitimate purposes which the government or the law permits, are if it can be used for any other purpose with the consent of the data subject. Of course, data subject is the word used in European countries, OECD countries. In our law, we are using the word data principle in place of data subject. And the fifth principle is security safeguards principle. Security safeguards principle is again concerned about the safety of the data that is collected. That has to be stored in such a way that it is not lost, it is not destroyed, it is not accessed by anybody else without any authority, it is not modified. the confidentiality of the data is maintained, integrity is maintained, and whenever sought by the customer, the person whom data belongs, that data is available for access. So all these things are the security safeguards that have to be ensured by the person who collects the data. So security safeguards principle is one very important principle that has to be adopted and that has to be taken care of by the organizations which collect the data, and that is a mandate of OECD guidelines. And the sixth one is openness principle. That is, there has to be transparency maintained with respect to developments, practices, and policies with respect to personal data. Anything and everything that is done with the data has to be made known to the customer, whether it is the reason for which the data is it is being used, or the how it is going to be processed, what all is being done with the data. Everything has to be explained, or it has to be made known to the customer or the person about whose data has been collected. That is openness principle. And the seventh one is individual participation principle. This also is very important principle. Individual participation principle, according to which that person whose data is collected is allowed to participate in processing of the data. That is, he is consulted before using his data. He participates in not only giving his data, but also in modifying it, in deleting it, in erasing it, or in updating it, or in restricting the processing of data. He participates in all the aspects, in all the activities of the data that is stored, collected by the data fiduciary or the data controller. So that is one more important principle that has to be kept in mind before making any law, and OECD countries abide by this particular principle. And lastly, accountability principle. For any kind of use, misuse, or abuse of data, if any harm is caused, the organization which collects the data is accountable for harm that is caused or the damage that is caused by the organization. So this is how the 8 principles were adopted by the OECD countries, and still they are following these principles. These principles, accordingly, the OECD guidelines, they went on updating, amending, and I think in the year 2013 they amended, last amendment took place, and now also they are relying upon these principles only to adopt laws nationally. So keeping these things in mind only, and when the problems increased and the problems of big data started causing a lot of potential harms and all, the European Union thought of coming out with a separate regulatory mechanism that is known as GDPR, which we often discuss. The GDPR, which was adopted in the year 2016, but came into effect in the year 2018, which also follows the same principles, but in different terminology, and they clubbed some of the principles and came out with the new principles. They come out with 6+1 principle, that is 7 principles. It is not only the European Union comprising of 27 countries, but also the EEA, European Economic Association, which contains additional 3 more countries. They have adopted these principles, which are depicted in Article 5 of GDPR. They are lawfulness, fairness, and transparency. That is the first principle that is adopted by the GDPR. Of course, all the 8 principles can be mapped into this particular principle. All the 8 principles of OECD guidelines can be mapped into this. Whatever you do, you have to be transparent and fair, and it should be legally permitted. That you have to collect it according to the law. You have to collect for a specific purpose, and for that purpose only you have to use. So that is lawfulness, fairness, and transparency, first principle that is used by the GDPR. Second principle is purpose limitation. Here OECD countries talked about purpose specification and use limitations principle. They combined together this GDPR, made it as purpose limitation. That is, collect data for specified and legitimate purposes, and that data has to be used for that purpose only, and that data has to be used with the explicit consent of that particular customer. So that is purpose limitation. You cannot use it for any other purpose. You cannot use it beyond that purpose. You cannot even retain it beyond that after the purpose is served. That is, again, in continuation of that, another principle that is adopted is storage limitation. That is, you can retain it only as long as the purpose for which the data is collected is served. Once the purpose is served, you have to delete it. So keep it as long as it is necessary. Of course, this storage limitation concept was not there in OECD principle. It was added by GDPR. You can retain it only if the data is pseudonymized. That is, user's identity is protected. Then only you can continue to retain it. Otherwise, you cannot continue to retain it. So that is another principle that was adopted. The another principle that is adopted by GDPR is proportionality or data minimization. That is, again, a combination of collection limitation and use limitation combined together of OECD guidelines. Limit the amount of data. You will need to review what user data you have and why moving forward. Only capture the minimum amount of user data you need. That is, you have to limit yourself to the amount of data that you require for the purpose for which the data is collected. You cannot collect more than that. So that is what is the proportionality or data minimization concept that has been used. Data minimization word is freshly used by GDPR, which was not used earlier by the OECD countries. Another principle is accuracy. That is, again, the data quality principle, which was used by OECD country guidelines. Data quality principle and individual participation principle both can be mapped here, wherein the data that has been collected must be accurate. It has to be kept up to date. It should be complete. It should be. It should not be manipulated. It should be true information, etc. And the user is allowed to update or delete the data. So that is the part of this accuracy principle, and that is another very important principle followed by the GDPR. And lastly, one more principle is integrity and confidentiality. The OECD countries followed security safeguards principle. The same thing in terms of integrity and confidentiality principle comes in. Here, data has to be safeguarded. It should not be misused or abused. It has to be protected. In addition to OECD guidelines, GDPR recommends for encryption of the user data and privacy by design processes, so that the adequate safety is ensured of the data of the users or data of the customers. So these are the 6 principles, and all the authorities or the data controller has to ensure that these 6 principles are followed. And accordingly, the law is followed by all the member countries. So that is the duty of data controller, and that accountability is fixed on the controller, and he has to ensure that compliance is followed. That is the 7th principle followed by the GDPR. Why I took or explained all these things is, these are the foundations or these are the principles of data privacy based upon which even our law is enacted. Of course, in GDPR and OECD, they have specifically mentioned these principles first, and then they went on mentioning the rules or the do's and don'ts, the rights and duties of data fiduciary, data controller, data subject, etc. But here in our Data Protection Act, we don't have them as principles. Even in the bills also, earlier bills also, 2020 bill, 2019 bill, or even in 22 bill, we did not mention them as principle. We have them in the form of obligations. Same principles in different form or different content we have in our law. Lawfulness is there in section 4 of the Data Protection Act, which deals with the data processing according to the Act for lawful purpose. The data has to be processed according to the consent given by the data principle, and for legitimate uses. That lawfulness has to be followed. Purpose limitation is there in section 7 and 8 of course, I have just taken examples. Everywhere it is mixed up. Everywhere the different rules and regulations have been made in order to rights and obligations are imposed having regard to these principles only. It should be used for specified purpose only. You cannot use it for any other purpose. Of course, there are so many other purposes listed in the act itself. There are many purposes like medical emergency or some kind of purposes which are for the public interest and all. There are so many purposes listed, and for those legitimate purposes also, and for various benefits that you are going to get from the government, for those purposes also the information can be used, and of course sometimes the consent may not be obtained for these purposes. So purpose limitation principle is followed, subject to the exception that the government can use it for some other purposes lawfully. That was there in even the OECD and GDPR guidelines as well. Then collection limitation is there in section 5. That is, you have to collect only that data which is necessary, and that too when only consent is given by the data principal. Here in our law, there are two important things which are predominant, that is notice requirement and the consent requirement, in which almost all these principles are followed. That is, the transparency has to be there, you have to specify the purpose, you have to give notice, adequate notice at the time of collection of data itself, and how that data is going to be followed or the process, and the right to complain if your data is not processed properly or it is used for some other purpose. You have the right to complain. Grievance redressal mechanism also is given. For that purpose, the rights of the data principle also have been identified in our law. So I think that this is some kind of deviation we can see in our law from GDPR as well as OECD guidelines, wherein we have recognized the rights of the data principle, as I think somebody observed in the previous lectures. So that is one more thing. And data quality, with respect to data quality, we have section 8, which mandates the ensuring of completeness, accuracy, and consistency of data when processing to make a decision or transfer of to another data fiduciary affects the data of the principal, the data of the data principal. So the quality of the data has to be maintained, and adequate security safeguards have to be ensured, and transparency in this connection also has to be maintained. That all is there in section 8 and 9 of the our Data Protection Act. And again, retention, you cannot retain it after the purpose is served. The data principal is given the authority to withdraw consent, and he can get it deleted. He can demand the access to his data and the quality of data maintained, and he can also ask the deletion or destruction of that particular data. So that is the right given to data principal under our law. So retention restriction also has been introduced in our law, and individual participation in this connection has been ensured in section 12, where data principal is given various rights to get it erased, updated, corrected, completed, up-to-date maintaining of the data can be ensured by the individual, so that those rights are given. And in this connection, the accountability, of course, is the principle which need not be specifically told. If you do not follow the law, then the respective person is accountable. Otherwise, you will face penal consequences. The data controller, data fiduciary, and the data principal, respectively, are held liable for not following the law, not following the law, and they may be imposed a penalty also. So this is how these principles, which began with OECD, have been adopted by the GDPR, and the same things have been adopted by our Indian law, that is Digital Data Protection Act. So this is just I wanted to highlight, and how our law comprehensively has adopted various principles that relate to data privacy and data processing. In this connection, just a few more observations regarding the previous speakers. First one is regarding Aryan Babeli. He said the data regulation must be rule-based, not rather than principle-based. I do not agree with that. It's first principles should come first, and based upon principles, the rules have to be designed. So it is only after the rules are notified by the government, we will be able to assess the pros and cons of this enactment properly. That's what I feel. And regarding Aparajita Bhatt madam's observation regarding datafication, which is not mentioned in this law, or no law in the country, in the whole world mentions about datafication. Of course, that is, I think they will not mention also. If they mention, then there will be no free service given by any service provider. We are getting these free services because we are giving our data. If we stop giving our data, if we ask them not to use our data, then we won't have service. If they start charging, it will be very heavy, and we will not have any kind of service, even including email service or exchange of data, whatever service they are providing on social media platform as well as internet, everywhere. They also incur huge expenses in giving this particular service, and benefit or the profit that we get is in the form of free service of using WhatsApp, Facebook, internet, the email facility, etc. We all get, even the Zoom also is available freely for a certain period. Okay, so all this is possible because they are giving this service. Otherwise, we wouldn't have seen this kind of crash of the distance. Wherever we are in the world, we can communicate now. We can see each other. That is possible because of these companies. So that is why I think datafication will never be a reality. If it becomes reality, it will be very costly affair for every individual to communicate with each other. So that's what is another observation that I just wanted to add. Thank you. Thank you so much for giving the opportunity. I'm sure I'm within the time limit given. I have completed my presentation. Thank you. Thank you so much.
Thank you, Sharda ma'am. You have, within time limit, very efficiently covered the various dimensions of the global perspective, that is from OECD to GDPR and then to Indian Act, recently enacted Indian Act. Yes, to some extent you have your own argument that nothing is free. If we are sharing our data and that data is being manipulated, analyzed, and used, then in return we also get some services. So it is up to you, us. If I want free WhatsApp, free LinkedIn, I share a lot of data, and then they structure or restructure it and make out of it. So the thing is free. There is no free lunch, as it is said in the life and in the business. Thank you very much for your presentation. We have few guests, and I have requested them to please share their coordinates so that we know, because we maintain our record for our of all our activities and events who join, and so therefore, please, those who have shared, thank you. Those who have not shared, please share your coordinates either to me in my mobile number or here, so we can take note of that. Prachi, please take note of that. Those who are our guests, our members' details are always with us. So thank you very much, madam. Over to you, Prachi.
Thank you so much.
Ocha, one thing I would like to say, Prachi, please.
Yes.
I already mentioned in the chat box, Dr. Sharda Patil, madam, was the recipient of the first award for our International Blockchain Advisor course, which we did in 2019, if I'm correct. It was Infinity Law Tech Educational Services at that point of time, which later has become Galter with more broader canvas. And we did a international diploma course along with the GBA, Government Blockchain Association USA, and Satoshi School of Germany. And there were 13 participants for that course, and she was the topper in that course. So we really appreciate your learning, Jill. Why I wanted to say this is that I have found her learning every new innovation and every new area of law and technology. Thank you very much.
Thank you
Over to you.
so much.
Thank you so much, Dr. Patil, for that, for those enlightening presentations, and Dr. Bhandari, sir, for enlightening us about Dr. Patil's achievement. Now, with immense pleasure, it is the time to hear from the person behind Galter and who has motivated, inspired, and mentored us in the field of technology and law. That is respected Professor Dr. M.K. Bhandari, sir, himself. But before inviting you, sir, for your valuable insights on this topic, I would like to take this privilege to introduce you briefly.
I think everybody knows. Thank you. Thank you.
But sir, still, sir.
You can, okay.
So very briefly, I would
please be
introduce
brief.
you. Yes,
Be
sir.
brief.
With more than 45 years of teaching, research, mentoring, and administration of institutes of higher education and playing key role in the establishment of institutions of higher education, Professor Bhandari, as a founding director, has established India's pioneering educational startup, early styled as Infinity Law-Tech Educational Services, now Galter, which works on highly transformative technologies such as blockchain, artificial intelligence, fintech, IoT, and a lot more, with focus on their interface with regulatory compliances. He had been a director, legal affairs and legal education at NIMS Mumbai. He was also the dean and director of Amity University Mumbai, and had been the assistant professor as well as dean and director, faculty of law at JNV University, Jodhpur. He has made large contributions in the field of law through his publications, and with around more than 80 research papers in international and national journals of repute, he has an active participation in the presentation of papers in national and international conferences and organizing the same as well. Dr. Bhandari's contribution in the field of law tech and his passion in the field of disruptive and highly transformative technologies is commendable and inspiring. And lastly, without forgetting this time, Dr. Bhandari is a lifelong learner and a passionate and enthusiastic academician. Sir, we are truly lucky to be associated with you, and I respectfully invite you to share your insights.
Thank you, Prachi, for brilliant introduction, and thank you especially for mentioning that I am lifelong learner. Yes, honestly speaking, I am lifelong learner, and my hunger for learning is still very active. Thank you very much. Friends, we have the benefit of listening to our great scholars on variety of aspects of the data protection at global level, and also the analysis or dissection of Indian Data Protection Act. In fact, I don't have much to share, and rather I would prefer that we have a interaction. We have very senior members and our young new friends who are present. So we would like their opinion. I would simply highlight certain points which are relevant to this roundtable. Number one is that the enactment of this act recently is an experiment, a bold experiment, although many countries have done it, and we have also joined that League of Nations now who can say we have a data protection law. As we all know that India is leading from front the digital revolution across the world, and particularly in the fintech space, we are number one in UPI transactions in the world. So how much data, personal data, our account numbers, our bank details, our mobile numbers are shared to the UPI platform. Crores and crores of details are there. Then we are number one in mobile telephony. And again, you can say we are being the largest populous country now, putting China behind. Now we have smartphones, we are using social media platforms extensively, which is a major source of creation of data. Dr. Yatin already explained how much data we are being collecting every day, every hour. So in all this scenario, we have come out with a Data Protection Act, Digital Private Data Protection Act. It's a good beginning. And as Aparajita rightly said, that every law needs timely changes. And that depends upon our experiences. When we will have proper rules, which must be in the process of making, we also can take a pride that we shared our inputs in consultation with some of our members. Dr. Sharda Patil was there in the team, and we shared our inputs with Niti Aayog and Ministry of Electronics about the data protection law. And now we are working on Digital India Act, proposed Digital India Act. So we believe that no law can be perfect. No law, whether it is a civil, criminal, revenue, even Constitution of India, which runs the entire destiny of this country, has seen more than 100 amendments in last 75 years. Now we are again going to have an amendment. So it is an ongoing process. We must highlight the better aspect of the law, and we must also point out the points which we have missed in the current law. The better aspect, I would say, is that the different authorities, the infrastructure of authorities has been created, from data producer to data manager, then other data protection board, appellate tribunal, which will look into the appeals, and all other agencies, enforcement agencies, they have been created. And their roles have been defined nicely. Again, there may be some more clarity needed, and much will depend, let me tell you, when the rules come into force. Because normally, as per the principle of jurisprudence, the rules cannot override the act. The rules cannot override the statutory section of the act. But much will depend how the rules are framed, how simplification is done in the rules regarding the various procedures of data processing, data collection, data erosion, consent taking. Aryan was telling that Aadhaar paper has a huge consent mechanism. We want simplification. I have been telling this point again and again on various fora, that look to the income tax law, look to the GST law, how complicated we have made it. We don't want this act to be made complicated. I am happy that as of now, there are barely 44 sections, one schedule, and fairly, I would say fairly, the act is in a simpler form. There is one point which perhaps has not attracted the attention of our speakers, that if any consent is obtained in violation of the settled principles mean the settled provisions, then that consent is deemed as invalid. For example, the best part in this act I would like to highlight is that after every section, because it's a new law, the technology is itself a new one. So there has been a detailed illustrations, as we have in contract law, as we have in penal law, that if this happens, this will be offense. If this happens, this will not be treated as a murder. Every illustration has been given. If this kind of agreement is done, it will be a voidable one. It will be a void agreement. So easy to understand. Similarly, here also the illustrations have been provided in the act itself. So you cannot deviate from the provisions. For example, if you are going for a telemedicine consultation, the company takes your telephone number, fine. They will call you, they will conduct telemedicine consultation. But suppose if they take your consent, that please share the telephone connections of your group in which you are there, your WhatsApp group or your family group. No. Even if you have given the consent unknowingly, the Act says the consent is invalid. That consent is not valid because it has been taken contrary to the principle that minimum information, minimum data should be collected. Once the purpose is over, the data should be erased. You can also ask for withdrawal of your consent if it comes to your notice that data is being processed for some other purposes. The rights and obligations of the data producer, data owner, or data subject, whatever you call, the person who has a right to control over his or her data, they are mentioned. You have a right also, and you have a duties also. Duty in the sense that you should not give false data, which may cause harm to the data processor or data collector. Similarly, Schedule 1, there is only one schedule as of now, which prescribes the penalty. The maximum penalty is 250 crore rupees and minimum is 50 crore rupees. All details are there that under this section, if violation takes place, this will be the penalty from 250 crore to 50 crore. In GDPR, I have seen the maximum penalty can be 4% of your gross revenue. If a company is earning 5,000 million euro and they are found guilty of data breach, then 4% of their revenue can be the maximum penalty. We don't have that kind of arrangement, but the penalty amount is fairly large. 250 crore is not a small amount, or even 50 crore, which is the minimum penalty, is not a small amount. Now, what is needed? Let this act be enforced in its letter and spirit. Let those companies who are found guilty in due course of time, after due procedure of law, proper inquiry, let those companies be penalized and let them be imposed the fine, maybe of 250 crore or 50 crore. A message will go to the whole entire data processing industry, e-commerce industry, or other companies that in India, the law is not a weak law. The law is effective law. The machinery, the appellate tribunal, the data protection board means business. If we are committing foul practices, contrary to the letter and spirit of the law, we are susceptible to the fine. Let it be implemented. So time will tell. Much will depend upon the success of the law. Law is there. We are discussing various provisions of law. Yes, there are some deficiencies, as I said. The Section 7 read with Section 17, where the entire provisions of the Act have been exempted. The certain areas have been exempted from the applicability of Act that is very wider. That needs to be clearly, boundaries need to be clearly defined. Perhaps a message goes, perhaps, that the Act is more friendly to the industry than to the individual. It is a subject matter of debate. I am not going to come to any conclusion here, but somewhere a message goes if we read those sections, the manner in which there is a deemed consent, the manner in which the exemption has been granted to certain category of areas. Some are very rightly there when there is an integrity of the nation, crime investigation, judicial matters. There, the deemed consent can be treated. But in other areas, the Section 7 and Section 17 need to be relooked, I would say. And maybe in due course of time, the legislature, the parliament may amend those provisions and give more powers in the hand of data producer or data holder. Let us see. So these are some of the issues on which I think time will say. And finally, I would like to say, much will also depend. See, making law is one part. Part 1, scene 1. Scene 2 is execution of the law, implementation of the law. And it is only when the implementation is taking place, we come to know about the actual deficiencies. oh, we did not think of that. So we need to amend the law. And in implementation of the law, again, as a student of law, based on my experience, I would say it's a cooperative approach. Alone, we cannot pass on buck to the agencies. We need cooperation. The people, the persons who are sharing data must be vigilant, must be alert, must be educated of their rights and duties under the Act. And this is what we are doing. All over these programs, all our proposed courses and other educational programs are part of that education. Let our Indian people, because most of the people are still in the villages, though they have a mobile phone, though they are using sensitive data and sharing sensitive data, but they are not aware that there is a law which gives us certain rights. We can check the companies, we can ask, as Sarda ma'am rightly told, why are you taking my telephone number? I have purchased certain garments, I have made you the payment, matter is over. Why are you asking for the telephone number? And I know after taking those telephone numbers, immediately they start promoting their products and wasting my time. I delete them. There is a flood of the emails in my mailbox every day, not less than 100 mails, and it takes me at least 15 to 20 minutes to delete them. This is all misuse of the freedom they are having. They are abusing. Even the governments have changed. The Facebook has been found guilty of meddling with the elections in the US on behalf of the Russia. These are the recorded things. There are many other cases, recorded cases, where these companies have been found guilty of data breach. So all these things would depend upon how alert we are, how active we are in claiming our legitimate rights, and also how cautious we are in sharing our data. Why should we unnecessarily share our data? I always tell it on Facebook and on other platforms. Why we do share some objectionable pics and other things? Later on, they are subject to be morphed and used and abused. Why should we click on unknown link or unknown number? There are so many things which we need to educate ourselves. So with these words, I thank all our learned participants, panel experts who have shared their insight into the various dimensions of the data protection and data privacy. And we must appreciate the efforts of the government, legislature, that they have come out with the law. And let us see how this law is implemented in time to come. Thank you very much. Over to you, Prachi.
Thank you. Thank you so much, sir, for such a practical and informative presentation. Now, after all the enlightening and mind-boggling presentations, with the due permission of Bhandari, sir, I would like to open the floor for discussion and question-answer session.
I think Anuradha madam has left. I would like to invite her because on last time she also participated in debate.
She's not there.
If she has left, fine. Yeah, now it is open as Prachi is handling the discussion. Prachi,
So the
you can.
participants may post either the questions in the chat or raise their hands if they wish to share their insights or ask anything relating to the theme of the event briefly. So we'll call upon or invite you for the same. If any of the participants would like to speak about the theme or any of the sub-themes of the event.
Please do participate. That would make the real benefit. Professor Yugal Kishore, would you like to share your views?
I'd be certainly happy to speak a few words.
Yeah, please, welcome.
Sir, one thing I'll certainly acknowledge that this particular panel discussion was very, very informative, interesting, and it was in fact very essential also for everyone to know. And therefore, I'm very much grateful to you, sir, also that you are always doing such type of activities so that at least many of us, we are getting proper information. But one or two things I feel like that something has got to be done in. But I agree with you that, as you have said that it is just experimentation going on. But when the matter of big data is there, when the companies like Facebook, LinkedIn are involved, then keeping it the maximum punishment up to 250 crore has got no meaning. So it should certainly be not limitation should not be put in looking into the type of data breach which is happening every now and then. So because it's a big data and our population is much and we are not much aware of. We disclose our information. Everybody going for something in the Facebook, every day you see something is being there. Anyway, so that is one thing. And the second thing, for that also I would request that some provisions should be made somewhere in the rules or somewhere. If it so happens that whenever some service providers are there, they are asking, they are giving services to us, then they ask us to give consent. And in that consent, there are so many big details are there. And last time also we were discussing, at that time we are not capable of going through with those discussions, with those rules. And if we deny giving the consent, they are not going to provide us services. And therefore, our consent is taken forcibly. And thereafter, that is being misutilized. So something has got to be done therein also, on that front also. Because that is very essential. Because I have always seen, whenever any website will be using, any software we will be using, they will be asking us for our post consent. And so there has got to be some, of course, you have rightly said that minimum information should be given, and if the information is not relevant, it becomes wired. So that provision, it should come strictly the rules that yes, if some information has been forcibly taken in the process of taking consent, and that is not that much relevant to the particular issue, then it should not be breached. And if it is broken, that should be taken to be a wide information for them. Third thing is authenticity of the information. Many a time the information which is being given or which is circulated, they are not authentic. And even on that basis also, the because it is widely circulated, so therefore the public opinion is formed. So some restrictions should be there also. Authenticity. I don't know, because my knowledge about these things are very less, and I have been, come to this forum because I found it very interesting, and I saw that sir is doing such a nice work, so I must enter into it, because I was never a student of cyber law and other things. But then one thing is there, I feel like that something has got to be there. Otherwise, it is very difficult. So I'm very thankful to you, sir. And I'm thankful to all the panelists also. So nicely, within the time constraint, they have elaborately presented and explained things in such a nice manner, in such a lucid manner, that the whole subject was made very easy. So I take this platform to congratulate all of them.
Thank you, sir. Thank you for your kind words, for encouraging words. In fact, you are one of the pillar of the Galter. Not only you, but you have also inducted many important members to the Galter family, and Prachi is one of them. Thank you very much for your suggestions also. Let us see how these suggestions are taken care of in due course of time. Prachi, can you have a group screenshot?
Okay, sure.
Because members are now depleting. It's already 1 and 2.5 hours.
I would request the remaining participants to kindly switch on their
camera. I thought, who is MK? Please unmute. So Prachi has come to Prachi has come to your city now. You know it. Prachi has joined UPS.
Yes, sir. Yes, sir.
So
Yes,
please
sir.
take care of her.
Yes, sir. I have met
She's your
Yes,
former
sir.
colleague. I need not to say. She's already your former colleague. Yeah.
Yes, sir. Definitely.
I'm very happy to see you.
Yes.
I'm very happy to see you, Madam Monica ji.
Along.
After a long time, I'm seeing you.
Sir, same here. Sir.
Yeah. Please, Dr. Chandrasekhar, please.
Thank you, sir. Thank you. Thank you,
Please.
sir.
Yes.
I would request Dr. S. Chandrasekhar sir to kindly switch on his camera. So can I just start with the photo?
I think yes, sir. Yeah, Dr.
Okay, so on the
Chandrasekhar,
count
please.
of 3, I'll just click it and it would just take few seconds. 1, 2, and 3. Done.
This is today I have inaugurated my new jacket, Modi jacket. Yeah, purchased 3 days back only. So I thought it is a good day. Thank you very much, Prachi. So now I would request Dr. Rajesh Methi. We met in Jaipur last month in some Bar Council sponsored moot court competition. He also came to judge that. And he is very active in promoting Indian culture and ethos. And he has recently joined Galter. Welcome, Dr. Methi. Would you like to share a few words about today's event, about other things?
Thanks a lot, Professor Bhandari. I'm blessed one that I am a part of this one August galaxy of the academicians and experts. And I'm lucky enough. It's a new area for me. So many times I read a lot of things. Recently, there is one article in Hindu and I was reading about the data. But I hope so. It's a new journey for me and we are on a mutual learning path. So I get a lot of things and it's just like a blessing from the Almighty because you met on the day and I joined Galter at here and I hope so I update and upgrade myself in a different manner. So thanks a lot. It was an amazing conference today. I got new ideas and I would like to explore at my level and if I have any query, so next time we will ask and it's just like a new journey for me from today. So thanks to you, and all of the speakers also, they enlightened me.
Thank you, Dr. Rajesh. Keeping in view your interest, we can certainly explore how the technology was there in ancient India, because what we are doing is just a tip of the iceberg, I would say. So we can also do some indigenous work about the technological developments in ancient India. Let us discuss and explore it. Thank you very much. Monica ma'am, would you like to say a few things? And I think, Monica ma'am, you can take lead at your institution and we will be supporting you in conducting some workshop or some faculty development program or anything in collaboration with other departments of your university about the data protection. Because we need to create a lot of awareness. See, just one event. We need to create a lot of awareness. Now, Prachi is there. Sir may come. I may also come. So please think of that. Would you like to say something?
Okay, sir, definitely. Yes, sir. I like some thoughts only.
Please.
One is, what is the impact of overload of information on human personality? Because while companies are profiting from the data and we are being benefited by the services, so what impact does it have on human health and one aspect of that? So what can we do about it? The other, sir, like you rightly said, what technology was used in ancient India, because exactly like the teleportation, which we are still saying that it may come in the coming centuries. So which India already had, when gods could go from one place to another. So whether those aspects of technology were there whether they can be validated by some means, and how today then we can use them in ensuring, or we can enhance our knowledge about Indian heritage and Indian. It was a valuable information that we have. So how that, because we knew everything about nakshatra and all the planets and everything to the precision of the point that exactly how far they are. Then there were the chariots which could fly in the sky like aeroplanes, and we had many other technology. So whether they can be validated through historical studies, and how our history can provide us that rich information. And sir,
yes.
Yes, sir. Thank you, sir.
Prachi, can I respond to your question, Monica ma'am's question?
Yes, sir. So so there's no need to ask.
Yeah. So, ma'am, you have raised first question about the impact of technology on human health, human life. Today only, in Times of India, I was reading in the morning newspaper, Sundar Pichai, the Google CEO, Indian-based, Indian origin Google CEO, he has given one interview to some Indian correspondent, and he has said that technology, excessive use of technology is making us isolated. And this is very clear. The more we are on telephone, more we are on WhatsApp, or any, I am also there. This is my weakness. I admit it. So more you are on the LinkedIn, you are disconnected with the social life. So that is the impact on health. Because the more our students are playing video games, they are susceptible to, now we are looking several instances where students, yesterday only in one of our township in Hyderabad, that is adjacent to us, one student committed a suicide by jumping from 34th floor. And because he was excessively addicted to the mobile games, and he performed very badly in the school, just a 14 years old boy. And because of the fear of admonition and other things, criticism, he ended his life. So that is the darker side of the technology misapplication. I would not say technology per se, abuse of technology. And we have to be careful. We have to create what Sundar Pichai has rightly said. Please maintain balance between the technology and your daily life. Spare some time with your family. Don't be engrossed in your mobile phone all the time. That is what one aspect of the technology. And again, the more we are using mobile, more we are generating data or sharing the data. Second thing is, I am reminded of one saint whom I had the honor and my privilege to meet him in Mount Abu. Mount Abu is a hill station of Rajasthan. He used to say, he was a great yogi of India. He used to say, I quote, the summit of science is a foothill of yoga. हिंदी में वो कहते थे कि विज्ञान का शिखर, जिसको हम कहते हैं आज हम विज्ञान शिखर पर है, पीक पर है, विज्ञान का शिखर योगा के ज्योति के बराबर है. अब अभी हम now we are having missiles, we are having spacecrafts, we are having aeroplanes. As you rightly said, there were the chariots. देव विमान एक स्थान से दूसरे स्थान जाते थे. There was a transmigration of body. The saint used to leave the body and enter into another body and come back. So there are so many examples. But the point is, we need scientific evidence. Today, in today's world, modern world, we believe only in those things which are scientifically presented to us. So that kind of research we need to do. We need to re-explore our glorious past scientific talent. This is what I would say. That is what I was telling to Dr. Rajesh Methi. We have many such areas. You know, German people came to Kurukshetra with certain instruments, highly powered instruments, and they have recorded the Kurukshetra conversation which took between Arjun and Sri Krishna. So though they are codified, but they could say, they could prove that yes, 1,000 years back, there was some battle and we have recorded some sounds of the battle and some sounds of the talks between few people. It could be Arjun and Krishna, or it could be other thing. So that kind of evidence-based research we need today. We have a very strong, glorious past. Our Vedas, our Upanishad, our other sources, they have a great reservoir of knowledge, and we need to re-explore, reinvent them. This is what I think we need to do. The young generation, the scientific temper, that is what our fundamental duties say. Develop the scientific temper. This is what I can say all about what you have raised. Anybody?
Bhandari sir, Rishika has raised her hand.
Please do ask. Yes. Probably we can have our last question. Dr. Chandrasekhar, would you like to say?
No, sir. I'm in examination busy, sir. Please.
Okay. Thank you for joining. Yeah, Dr. Rishika.
Yeah, good afternoon, everyone. Good afternoon, esteemed panelists and everyone here. First of all, let me share my experience. It was a wonderful discussion, and I've gained so much insight during this discussion. And I am right now pursuing PhD in cyber law under Professor Dr. V. Vijay Kumar, sir. He was former Vice Chancellor of National Law Institute, University, Bhopal. He gave me the link and asked me to attend this discussion. You will gain some insights, do attend it. And definitely I did. So thank you all. Just to add on to the discussion, number one, I would like to agree with, of course, Yugal sir, since he said the penalty, there should not be an upper limit to the fine, because if we hypothetically, if we take an example of Meta or Google, their yearly turnover is nearly 20 to 25 billions, and if we convert our 250 crores into US dollars, it barely comes down to 30 million. So that in that sense, 30 millions for Meta could be said as the amount to run a business. Just like 10 million fine is for Meta is an amount to run the business. It's fine. Plus another thing is, since I'm doing my PhD in child's privacy, so I would like to have this discussion or sometime later maybe focused on protecting children from children's data privacy in this whole surveillance capitalism, in the age of surveillance capitalism, how this bill or how this act and different acts around the world help specifically to protect data privacy of children. Because there are still some lacunae there in this DPD Act as well regarding that. So I would definitely, it would definitely be helpful to gain insights from you all regarding this particular thing.
Thank you, Rishika. Yes,
you.
Dr. Vijay is a very good friend of mine. For last almost 30 years, we have been regularly interacting, meeting on different occasions. I visited NLIU Bhopal couple of times, and in fact, we did a national conference together on blockchain 4 years back,
yes.
prior to COVID scenario.
Correct.
So your current Vice Chancellor is also our friend, Atul Pandey, and all these things.
Yes,
all the members. Yes, I have visited your Center for Cyber Security and conducted some lectures. So it's my pleasure that you have joined. And if you want to be part of the Galter, you can share. I have shared my number, Vijay, as my number, or you can write to me, contact me, and we can admit you as our member. So that would be great. Yeah. Thank you for participating.
Thank you so much.
Yeah. We have a new friend just now joined, Timilehin. Mr. Timilehin? Hello? Mr. Timilehin? Can you unmute yourself, Mr. I think.
So there's one more new person who is joining, Soumya.
Soumya was there? No.
No, sir. She is just.
There's no point in joining at this concluding time, and we are closing anyway. Yeah, okay. So I think he
So
has
should
not.
I move forward?
Yeah, please move forward. Okay.
Thank you for all the participants for their active participation. Today we have journeyed through the intricacies of digital revolution, understood the weight of the responsibility that accompanies digitization. We have also delved into the pivotal role of data protection. Also, the landmark Digital Personal Data Protection Act 2023, as was highlighted today, underscores India's dedication to fostering a secure digital ecosystem for its denizens and businesses. We have been privileged to hear from experts in the field, each shedding light on specific areas relating to data privacy and protection. From the broad understanding provided by Professor Dr. M.K. Bhandari and Dr. Aprajita, and the new concept of datafication discussed by Dr. Aprajita, the insights into authorities and enforcement by Mr. Aryan, the exploration of data and metadata by Dr. Yatin Katoria, to the deep dive into the American continent's challenges and solutions with Dr. Amana Alkali, and the foundational principles elucidated by Dr. Sharda Patil. Every perspective presented today has enriched our understanding, setting the stage for productive dialogues in the future. It's heartening to see the collaborative spirit with which everyone has come together today, which is a Sunday. So let us take forward the discussions and learnings from today and contribute towards a safe, secure, and transparent digital world. With this, I would like to invite Dr. Professor M.K. Bhandari, sir, for the last vote of thanks. Over to you, sir.
You have already thanked all of us. So now my duty is only to thank you for very ably, timely, and efficiently conducting the entire roundtable proceedings. Thank you, Prachi, very much. And of course, thanks to each and everyone who participated as panelists as well as participants. I think it was a great core learning and sharing experience for all of us. Thank you. Namaskar. Now enjoy the rest of the Sunday, and please seek my apology with your family members for keeping you engaged on the Sunday morning. Thank you very much. Namaskar. Jai.
Thank you all, and on behalf of Galter, we look forward for this continued association for the further events that we conduct. Thank you all.
Namaskar to everyone. I would like just to say one thing. Prachi,
please.
You have wonderfully anchored today, and the way you have done it, it was really an expertise in a sense. So thank you very much for that.
Sir,
आपने बहुत अच्छे लोगों को ऐड किया हुआ है, वो बहुत बढ़िया ढंग से उन्होंने किया।
आपने बताया सर, आपने बताया, आपकी प्रोडक्ट्स हैं, ये सब